Good morning to all of you. Andarki Shubhodayam. Welcome to Legal Matters by Sai Babu Sunkara. ఈ వీడియోలో డైయింగ్ డిక్లరేషన్ గురించి చెప్పుకుందాం. Whenever you discuss the topic of a dying declaration, we will be remembering the very famous case of Pakala Narayana Swami or Pulkur Kotaya, like that. Here the important point is the dying declaration need not be addressed to a particular person. If he utters, అరే ఈ నన్ను చంపుతున్నాడు రా బాబు అని అరిచారనుకోండి, అది ఒకళ్ళు విని చెప్పారనుకోండి, it also becomes dying declaration. This is what is stated by Orissa High Court. The case law is Justice Sangam Kumar Sahu and Savitri Rathore. In the case of Daktar Bhoi, DAKTAR, Daktar Bhoi versus State of Orissa, JCRLA number 21/2020, decided on 8/4/2025, wherein it was clearly held that DD need not be addressed to a particular person. And when the deceased was yelling in pain and when he is disclosing the name of a particular individual, disclosing the name of the murderers, definitely it can be accepted as dying declaration. Of course, court should satisfy about the voluntariness and also the veracity of the declarant. This is already, this is a saving clause. If the court is satisfied that the DD is voluntary, if the DD is truthful, of course you all know that DD is not the sole evidence. It is not the conclusive proof. Normally the courts take it as a corroborative piece of evidence only. If no other evidence is there, definitely, as you all know, section 32 of the Indian Evidence Act, it is an exception to the so-called hearsay evidence. It can be decided. Right. So what is the concept of the dying declaration? Already I told you. The main concept is truth lies on the lips of the dying person. That means a person in acute agony is not expected to tell lies. In all probability, he will disclose the truth only. Coming to the facts of the case, it relates to a case of Damkipalli village in Odisha. The case is under section 302 and also 201 of the Indian Penal Code. It so happened that on 28/6/2009, when the complainant was sitting or taking rest after lunch, two witnesses, actually they are his uncles, PW13 and PW16, they came to him running and said that his father was attacked. His father was attacked by the accused persons, Daktar Bhoi and others. Actually, they caught hold of him, they tied his neck to a wooden post and also actually stabbed him. And when these people, actually how they went there, PW13, he said that he heard some sound, dada sound ochindi, aa sound tho akkadiki vellanu. PW16 says, Daktar is said, the deceased is saying, Daktar is killing me, please save me. Endukani em kavali? He is killing me, please save me. So these words heard by the so-called PW13 and 16, whether they become dying declaration or not. Please remember, the lower court also agreed the same. Right? No doubt. The police, as usual, they have completed their investigation. They obtained the PMC. PMC said the postmortem certificate. It says that death is due to brain injury plus shock. Okay? Since he was tied, shock. Asphyxial death. Then brain injury, they hit him, stabbed him like that. So anyway, here the point is whether the statements of PW13 and PW16 can be taken as dying declaration or not. And actually what happened is after they went there, the accused threatened PW 13 and 16 with the dire consequences, and they saw these people taking away the dead body, keeping it a gunny bag and throwing it to the jungle. 302, 201, two sections. Right. So, actually, the lower court convicted the accused for life imprisonment. Against this, they approached the High Court. High Court said, High Court did not accept it as non-declaration because it is not stated to anybody, no specific individual. So, since no specific person is mentioned, since the DD was not given to any specific person, it can be taken as a DD under Section 32 of the Evidence Act. Right now, the matter came to the Odisha High Court. Then, so that is Division Bench. Division Bench clearly stated that the statements of PW 13 and 16 clearly say that it is a dying declaration because under the threat or under yelling in pain, he disclosed that Daktar is killing me. Please save me. What more is necessary? Even though the single judge or the opposite lawyer said that their statements, the statements of PW 13 and 16 at most come under Section 6 of the Evidence Act, that is res gestae, fact forming the section, facts forming the same transaction. But the High Court Division Bench said, no, this has to be taken as a declaration. Conviction given by the trial court is justified. Very good decision. Please make it a mention whenever such things come to your notice, and this will be beautiful judgment for you. Thank you.